ask you both a question each, and you're both free to weigh in on these questions. So, Nicholas, starting with you, when do cash deposit requirements for importing start in an investigation?
Thanks, Al. That's been talked about quite a bit by John and Jay, especially with that critical circumstances determination. When there's got to be basically in all the basis, there has to be a decision in place. So in the investigations, there has to be a preliminary determination made that either dumping is occurring or there's countervailable subsidization going on before the government can put duties in place. They can't do it just because the domestic industry has filed a petition. That's because under the various WTO agreements, the countries agreed they won't just start because someone alleges dumping or subsidization. They have to look at it, make that preliminary determination. And that will typically kick in duty, they'll start collecting deposits. And again, those aren't finalized until a later review, so it can result in an additional bill or in a refund. The one issue with that is the critical circumstances determination, which can move that date back 90 days if they feel that importers have brought in a surge of the product to try and beat that date, so they have sufficient inventory they can sit on and sell off of for a long time. That being said, it's very rare for a final critical circumstances determination to be made. Commerce will make them quite regularly, but the ITC also has to weigh in and determine whether that surge of imports is likely to seriously inhibit the proposed function of the order, if it's going to take away from that relief in a very material manner, and they very rarely find that. So really the date is almost always that preliminary determination.
Thank you for that response. A question for Jay here before we wrap up. Jay, what are the latest developments concerning the Department of Commerce differential pricing analysis?
Yeah, I guess first, none of us really mentioned differential pricing, so I'll try to describe it quickly. But basically, it's a test Commerce employs to govern what type of calculation methodology it uses to determine the foreign company's dumping margin. Normally, Commerce compares average U.S. prices of the same product or to average U.S. home market prices. But if it finds differential pricing, meaning that the U.S. producer, the foreign producer sold the subject merchandise in the United States at significantly different prices with respect to different customers, time periods, or regions of the United States, then Commerce can use, under the statute, a different calculation methodology whereby it compares individual U.S. prices to average home market prices. And when Commerce uses that methodology, it does what's called zeroing, which it has been controversial in the AD world, a practice the United States adamantly defends and a practice that many foreign governments oppose. But what zeroing means is that in comparing those individual U.S. prices to an average home market price, Commerce does not give the foreign company credit for any comparisons for which the U.S. price was actually higher than the home market price, which would result in a negative dumping margin for that comparison. Instead, Commerce sets those negative dumping margin comparisons to zero, which would tend to have the effect of increasing the foreign company's dumping margin. Now, Commerce, I'll try to be brief, Commerce has employed basically the same differential pricing analysis now for a number of years. It has been litigated in U.S. court, but so far none of those decisions have prompted Commerce to modify its existing practice. There is a WTO case, there are multiple, but the main one is washers from Korea, in which the WTO appellate body did decide that zeroing in the context of the Department of Commerce's comparison of individual U.S. prices to average home market prices, resulting from a finding of differential pricing, that zeroing in that context remained inconsistent with WTO norms, the WTO anti-dumping agreement, but the U.S. Department of Commerce has not sought at this point to comply with that WTO decision. So this is kind of a long-winded way of saying that actually nothing's really changed with respect to differential price.